The next case is Treasurer versus Scheibe. If I'm saying that anywhere close to right, if I'm wrong, I apologize. Each party will have 15 minutes to present their argument. The appellant may reserve up to 5 minutes for rebuttal. Counsel, how long would you like to reserve?
I'd like to reserve 5 minutes.
5 minutes for rebuttal, very good. I'm keeping time up here. You may also try to do that on your device, but I will try to let you know when we're about a minute left in your time. For your initial time, I will not give you that warning on rebuttal time, just so you know. And counsel will try to let you know about a minute in your time as well as the appellee. When you come to the podium, the argument being recorded, so please introduce yourself. Please make sure to stay behind the podium and speak loud enough so we can hear you. You should not refer, and I don't think it will apply in this case to any minor or child or a victim. I don't think we have anything like that to worry about in this matter. But if you were, please refer to initials or something other than direct names. With that, the court's ready, your briefs are ready to proceed whenever you are.
Wonderful. Okay, I'm ready to begin.
Go ahead.
Well, good morning, Your Honors. It's a lovely hot morning today. I had quite the long drive from Cleveland to come in here, but I made it on time and I'm quite happy about it. So, good morning. My name is Logan Trombley. I represent Marquis Scheibe, who's the property owner of a 1.5-acre commercial property formerly used as the restaurant named Fiore's Italian Restaurant. I will refer to her just as the Fiore's property, make it simpler, or the property. So, the legal issue before the court today is simple, at least in my opinion, it's simple. And the question really is this: can a property owner who has delinquent sewer bills, right, and there's a lien created based off those delinquent sewer bills, and if they're foreclosed on, can they challenge the validity of that lien? And specifically, can they challenge it for being unreasonable under RC 611702 as an affirmative defense? And to remind you, that statute right there is the specific statutory authority by which counties have the authority to charge sewer rates. And this is not charging for improvements, this is charging just for what is already there. It was the Wayne County and the trial court's position that the property cannot do this because they first must challenge the validity of the lien, either using what they refer to as RC 611709, which is a procedure to challenge sewer improvement assessments, not regular bills, or the administrative appeal statute RC 2506, which I hold is not really an administrative procedure itself, it's an administrative appeal. Specifically, they argue that under this court's ruling in Tarvik, Mr. Scheibe should have exhausted those administrative remedies instead of now challenging this lien as an affirmative defense. Yet it's my client's position that the standard rules for foreclosure defense should just simply apply in this case. All liens are subject to a validity challenge. It doesn't matter if it's a mechanics lien, condo assessment, even a mortgage, right? There's nothing different about this lien. It's just statutorily how they created the lien. There's nothing special about it. It should be challenged. It should be able to be challenged by its legal validity. If it's not legally valid, it should not be able to be foreclosed on. It's that simple.
Well, I mean, this whole area of law, they're claiming it's a little different. You don't have exhaustion of remedies for a mechanics lien or other things. You do have exhaustion of remedies for actions by a federal or state government and their entities. So it is a little bit different. This could be an area that would be different. I'm not saying it is, but it would be different from those other type of liens you're referring to because of the exhaustion potential.
Well, and I'll get to it a little bit later, but just, the two ones they hold up. One is this statute 109, I'll just refer to it simply. That is not available for this type of stuff. It's for improvements. They never even cite or even could give you any plain language in their briefs or the trial court. Because if you took one look at it, you realize, oh, this is not applicable at all. It's about improvements. And the second one is the state administrative appeal. I have never seen one. Through all my case research on this, I didn't see a single time this law, right, this statute for the reasonable ones, was brought up in an administrative appeal. It's usually challenged via declaratory judgment action, is what I've seen. In the 8th District, there's a couple of cases.
Well, this is a little bit different, it seems to me. You start with what's passed to say, okay, we're going to have this procedure, and at some point, the director of sewer services, whoever the person's name was, will set these values for us. So you certainly could have challenged that at the time. And it was done, and decided, I don't think it's right or fair to declaratory judgment that this person has all this power to set these. Client didn't do that, that's fair enough, that's fine. Then time goes by, and there seems to be a dispute when there's a decision made again by the director to say, look, your person has to pay all this extra sewer rate, and your client doesn't agree. Well, that was an administrative action. Why didn't your client use 2506 in appeal at that point to say, this isn't fair, and I shouldn't have to pay this tax?
So you have to get into the specifics of this case is that, and this goes to this case law on this, where administrative appeal would not actually provide the relief that is being sought here. Why? Because when you do an administrative appeal, and I've done a million, you're isolated to just the evidence of that particular case, right? In this case, it would just be the seat count of that particular restaurant. That's actually not what he's challenging, is his counting of seats. We all agree how many seats there are in the restaurant. That's not the issue. What he discovered later, a couple years later, through a series of public records requests, that other properties around him were not being treated the same. During discovery in this case, we discovered that that was true across the board, that he was not, this property was being treated much more strictly than others. It was being audited, and its bills got raised. 10 other properties, I think 9 other properties got audited, they never raised their bills. And then also, this was strictly applied and overestimated, whereas others were underestimated.
Council, can I just get some dates and the timeline a little bit clearer in my head? The audit occurred in 2017, is that correct?
Yes, sir.
And did your client, the appellant, stop paying taxes at that time?
I believe...
Didn't he admit that he stopped?
He, honestly, prior to that, was not paying where he was just doing, he would wait for the lien to come in and then he would just pay it, right? And so he was current on that. It's a little iffy with honestly, with the discovery on that. I was not able to determine that because Wayne County lost its records going back 2020 prior and everything got wiped. So we weren't able to, I wasn't, to be honest with you, Your Honor, I really wasn't able to figure that out.
And is Judge Stevenson's question, is it true that Mr. Scheibe never challenged any of the sewage assessments through administrative channels?
I contend there is no administrative channel to challenge this. The statute that they cite is not proper for this. The only thing that you could maybe cite is the administrative appeal function, right? He did challenge it in terms of, he challenged it, called the director, challenged to the director, and then he also challenged it to the Wayne County Board of Commissioners and talked to one of the commissioners at the time, right? But there's never in the letter saying, oh, you have a right 30 days to administratively appeal this. He had no, as a layperson, notice to know that was the way to do it. And we all know that it's a very quick timeline to turn that around on an admin appeal. And he didn't have a full basis to do so at the time because, again, what he realized was the differentiation in treatment through public records requests later in 2019. And that's the core issue.
He doesn't file then. And is your position the only remedy he has is to wait until, to not pay, wait until the county forecloses and then bring it up?
I wasn't the attorney at the time. If I was the attorney at the time, I probably would have went on the offensive, right? Right now, we're in the offensive in federal court on this case and a civil rights equal protection claim, right? But he has a right. He doesn't have to. There's nothing precluding him in terms of doing a debt action or civil rights claim at that time versus waiting and then doing an affirmative defense. You know, I don't see any case law out there. And again, that's a debt action that would do it or a civil rights case. They're arguing administrative remedies. That's not an administrative remedy. That's a different type of case. And we all have, as an attorney, as plaintiffs, the rights to choose, how we want to go about it strategically.
On that point, did he file a counterclaim?
In this case, we did not file a counterclaim because we wanted to file the counterclaim in federal court, which we did, and it's ongoing because we didn't really, it was more of a forum issue.
And so his affirmative defense in this case is solely against the treasurer?
Yes, it's solely against, well, it's against Wayne County, right, the party of interest rate, and then the treasurer is the agent who is, on behalf of Wayne County, who is enforcing the lien, right? The treasurer doesn't have the personal lien, Wayne County does. And so it's just an affirmative defense saying the underlying lien is simply not valid, at least to the amount that it is right now. Wayne County never challenged the factual basis by which we said it was in their briefs. So, it's my position that they kind of left the field. They put all their eggs in this basket of the administrative remedies issue, which I find to be not legally sound based off this court's ruling in Tolerate, which specifically said the trial court in that case was wrong for citing exhaustion of remedies. This court said the reason that you couldn't do that in a property tax issue was because it's a jurisdictional question, because they created the Board of Revisions, and then there's an appeal from the Board of Revisions to the trial court, and that is the way by which they get jurisdiction. That's not this case.
About a minute left in your initial time.
So, I mean, I think that really is the core of my argument, and I think just the one thing to put out again is that I think there should just be a bench trial in this case. All I want is for the court to say, okay, he can raise this issue, it's valid, right? And then they didn't challenge it on their end of the facts, so we should win on summary judgment. But then now we go to a bench trial to determine the actual reasonable sewer fees. He's going to pay them. It's just, let's figure out how much. And now we're cut off at the knees at this administrative stage, at this stage. He should have done it at the pleadings level, the judge. Why he waited to summary judgment to do this, I think is also strange, but that's where we are now. I'd just like to get back to trial and figure out this issue, and I don't think it's too difficult.
Thank you.
Thank you.
Your Honors, may it please the Court, I'm Joseph Salzgaber, Assistant Prosecuting Attorney for Wayne County on behalf of Melissa Koch, the County Treasurer. What this case presents to this Court is whether or not Judge Spittler got it right in granting summary judgment on behalf of Treasurer Melissa Koch for delinquent real estate taxes, sewer assessments, penalties, interest, and the like, totaling $81,047.89 at the time of filing in 2022. I understand that this is a review de novo, but this Court has the exact same record that Judge Spittler had before him last year. Essentially, Mr. Scheibe had a dispute with the Director Wolf of Environmental Services over his sewer assessments. They were counting the toilets at his establishment, and that resulted in an increase in his sewer assessments. Instead of pursuing any remedy whatsoever, he just decided in 2017 that he was going to stop paying his sewer assessments. Then he decided to stop paying his property taxes altogether because those assessments were added to his property taxes. So we have someone engaging in self-help, not attempting any administrative remedies, not retaining an attorney, filing any kind of action in probate court or in the common pleas court to dispute Director Wolf's setting of the assessment for sewers. Fast forward nearly 5 years, the treasurer files a foreclosure action based on tax liens which have accrued over the course of a number of years. We come to court and Mr. Scheibe gets an attorney and decides that he's going to challenge the reasonableness of the sewer rates, which he has not challenged over the past 5 years. So the law is relatively clear. If you don't exhaust your administrative remedies, you waive that argument. You waive challenging validity of the lien and the foreclosure action. This court's own cases indicate that there's an estoppel, that argument cannot be raised. And we're going back to before World War II with respect to the Ohio Supreme Court cases that clearly indicate that there's a waiver of those defenses if you don't exhaust the administrative remedies. And that essentially is what Judge Spittler decided, that there was a waiver of these arguments. There was no question about the validity of the tax liens otherwise. And he didn't acknowledge not paying the taxes. In his own motion for summary judgment, he did not attach any expert opinion via affidavit to indicate there was anything wrong with the way Director Wolf had calculated those sewer rates. So there was no genuine issue of material fact raised by the appellant in his motion for summary judgment. And we believe that based on the examination of the record that this court should affirm the decision made by Judge Spittler on summary judgment.
And your argument in a nutshell, counsel, is failure to pursue administrative channels resulting in a waiver?
Correct. That is the essential argument, and he only challenges the reasonableness of the sewer rates, but he didn't pay his property taxes either. So, we would still be here in any event because he didn't pay his property taxes.
What administrative channel should he give you to challenge this?
Your Honor, in looking over the various statutes, the administrative remedy available under 2506.01 through 04, appeals from decisions of agencies of political subdivisions would have been the proper method for challenging Director Wolf's decision with regard to the sewer rates. I should note that Director Wolf did use the Green Book, which is an Ohio Department of Health and EPA guide for determining these rates where you don't have a meter. This is an unmetered property, so there were estimates made. If there's nothing further, we would ask that the court affirm the judgment below. Thank you.
See no further questions? Thank you. You have your full 5 minutes now.
A couple things. He contended that he did not hire a town attorney, did not challenge it. That's not true. He did hire an attorney back in, I think, 2019 time period who was doing correspondence back and forth, trying to challenge this through public records requests and letters going back and forth. There was never any clear indication from Director Wolf to Scheibe in any of his letters saying you can appeal this via administrative appeal. That's one point of it. So the second, and the property taxes are not the issue. We're not trying to dispute the property tax. He'll pay the property tax, or if it goes to a sheriff's sale, it would be that. It's just the sewer issue is the issue. The second is, he states the law is clear on this administrative remedy precludes us. The law is not clear on that. This court's decision in Tullerich said blatantly the trial court was wrong for citing exhaustion of administrative remedies as its reasoning. It was a jurisdictional question. So that is not true, and the cases he cites are all the way back, pre-World War II, right? Tullerich is pretty recent, right? In this court, right here. That's a good decision to go off of. I think it's the most applicable. Secondly, those cases all resolved around, again, cases where it was like sewer assessments, sewer improvements, right? And there was statutes created specifically to challenge those issues. There are statutes for sewer improvements. I would read 611709, which he didn't even mention in his argument, maybe dropping it because it's so wrong, is that it says any property to be assessed or taxed for an improvement under the section can challenge it in the probate court. That is not what's going on here. It's not an improvement. And the trial court just got that wrong. Finally, he also said, well, we didn't raise an expert report. We don't need an expert report to create a genuine issue of fact. I don't need an expert report to say he never audited, when he audited everyone else, he changed their bill. He didn't change their bill, but he changed my guy's bill. I don't need an expert to say that. I don't need an expert to just apply the Green Book, to a different property. It's pretty straightforward. Maybe you should have gotten it right the first time. So I don't understand why you would require an expert report to create a genuine issue of fact. If you look at the summary judgment motion, it has all the evidence provided as exhibits, and it explains the issue. They never provided a counter-expert report or any counter-argument to it. Therefore, they left the field open on that. It's just that was their prerogative, that was their tactical choice, and it should, come back to harm them. And finally, this administrative appeal, it kind of bugs me, is that it's not an administrative process. It's the trial court getting jurisdiction to rule over an administrative process, right? The administrative remedy is what's being appealed, and this is not, RC 11702 does not provide for an administrative process to challenge this, right? is not how it's built. It's built to be challenged using declaratory judgment or even a takings lawsuit I've seen, but I've never seen an appeal be an administrative appeal. And I think if this court were to make that ruling, it would have a huge effect on other cases, right? Where, administrative appeals can be used for a lot of things in a lot of situations. And if this court's going to make a broad paintbrush rule that if you don't administratively appeal something, that precludes you raising defenses or claims later, there's going to be a lot of follow-on effects, unforeseen consequences that come from such a broad paintbrush ruling.
Why is the treasurer the appropriate party in this case?
Well, it's just because under this, I think it's just how they captioned it, honestly. And I think they could caption it as Wayne County, they could caption it as
And you think it doesn't matter?
No, because
It doesn't matter if it was the auditor or the person who did the assessment?
I think under the
Yeah, that's
statute,
fair.
it specifically says the auditor, and I think that's where it comes from. But the real party of interest is Wayne County, right? The auditor's not getting the money,
Were the
person-
county commissioners? They weren't named, right?
No, because this wasn't a decision by the county commissioners, right? This is a decision by Wayne County as a whole, an agent of Wayne County, which would have been Director Wolf. And that's where the affirmative defense would go against. In the offensive action in federal court, those people are named, right? So if we did a counterclaim, that's what we've done. But I'm trying to do administrative appeal here, counterclaim in federal court. Just, probably would have been easier, right, for you guys if I did it all in one. But the federal court was where he preferred to do the, offensive action. And that's just kind of what makes this a little bit more clunky than usual, for which I apologize.
Counsel, I note your time is up. Thank you for asking Judge Sutton's question. You may briefly conclude if you wish to do so.
Again, I do think this is a simple issue. I think the court just needs to look at apply tolerant to the situation, and then allow me to raise my defense. And because they chose not to challenge my defense factually, the logical action is I have to get my summary judgment granted. But then
That's brief enough. Thank you, Counsel.
Thank you.
And I want to thank you both for your presentation today on behalf of the court. The court will take the matter into advisement and make a decision in due course. When that is decided, it will be mailed to you by our clerk of courts and also be posted on the Ohio Supreme Court website. And with that, I note we are now adjourned until our next meeting in Summit County.